So 202.26, Pretrial Conference, abbreviated as PTC. A. After the filing of a note of issue and certificate of readiness, the judge shall order a PTC unless the judge dispenses with it in a particular case. So remember, this is going to go from the general calendar onto the pretrial conference calendar, unless it's dispensed with, and then it would go on a reserve calendar. B, to the extent practicable, pretrial conferences shall be held not less than 15 nor more than 45 days before trial is anticipated. So if trial is scheduled for a certain date, the conference has to be within that time period. That's the 15:45 rule for a pretrial conference. C, the judge shall consider at the conference with the parties or their counsel the following 6 things. 1, simplification and limitation. 2, obtaining admission of fact and documents to avoid unnecessary proof. 3, disposition of the action, including scheduling it for trial. 4, amendment of pleadings or the bill of particulars. 5, limitation of the experts. And 6, insurance coverage where relevant. The judge may also consider with the parties any other matters deemed relevant. D, in actions brought under the simplified procedure sections of the CPLR, the court shall address those matters referred to in CPLR 3036 sub 5. E, when parties are represented, only attorneys fully familiar with the action and authorized to make binding stipulations or accompanied by a person empowered to act on behalf of the parties represented will be permitted to appear at a PTC. Where appropriate, the court may order the parties, their representatives, or insurance carrier representatives, or any person having an interest in a settlement, including those holding liens on any settlement or verdict, to also attend the conference in person or telephonically at the conference. Now, here they're calling it a settlement conference, which is ironic because they've kind of used this euphemism pre-trial conference, and then they kind of admit it's a settlement conference. They're trying to get you to settle. Plaintiff shall submit marked copies of the pleadings, a verified bill of particulars and a doctor's report or hospital record, or both, as to the nature and extent of injuries claimed, if any, shall be submitted by the plaintiff and by any defendant who counterclaims. The judge may require additional data, or they may waive any requirement for submission of documents on suitable alternative proof of damages. Failure to comply with this paragraph may be deemed a default under CPLR 3404. Absence of an attorney's file shall not be an acceptable excuse for failing to comply with this paragraph. F, if any action is settled or discontinued by stipulation at a pretrial conference, complete minutes of such stipulation shall be made at the direction of the court. Such transcribed stipulation shall be enforceable as though made in open court. G. 1. At the pretrial conference, if these 3 things happen, the judge shall order the case transferred to lower court pursuant to CPLR 325. Okay, so we need A, B, and C to get this automatic transfer to lower court. 1, it appears the action falls within the monetary jurisdiction of a court of limited jurisdiction. 2, there is nothing to justify it being retained in the court where it's pending. And 3, it would be reached for trial faster in the lower court. So if we have those 3 things, action falls within monetary jurisdiction, nothing to justify it being retained, and it would be reached faster in the lower court, the judge shall order the case transferred to the appropriate lower court, specifying the paragraph of CPLR 325 under which the action is taken. 2, with respect to transfers to New York City Civil Court pursuant to 325, if at the pretrial conference the first 2 conditions are met, but the case will not be reached for trial more quickly in New York City Civil Court, The judge, in their discretion, may still order the case transferred if it will be reached for trial in the lower court within 30 days of the conference. In determining whether the action will be reached for trial within 30 days, the judge shall consult with the administrative judge of his or her court, so that would be the Supreme Court administrative judge, who shall advise, after due inquiry, whether calendar conditions and clerical considerations will permit the action to be tried in the lower court within the 30-day time frame. If the action is not transferred to a lower court, it shall be tried in the Superior Court in its proper calendar progression. Okay, time limits and time rules. First, judge shall order pre-trial conference unless dispensed with, and that is done after filing of note of issue and certificate of readiness. PTC shall be held, and this is the 15 and 45 rule, not less than 15 days nor more than 45 days before anticipated trial date. Next, plaintiff shall submit copies of marked pleadings, and also for personal injury actions, you have to submit a verified bill of particulars, and this is at the pretrial conference. And then the last time rule is New York City Civil Court transfers pursuant to 325D, so remember those are with no consent, so the monetary amount remains the same, and the time rule is that the action must be reached by the New York City Civil Court within 30 days or quicker than it would be reached in Supreme Court. And the way that the justice in Supreme Court finds this out is that he must consult with his administrative judge, so the administrative judge of Supreme Court, to determine this. So we have basically 3 real-time rules. We have the 15, 45, and then the 30 days.